For Session Update, I'm Shannon Loehrke. At Monday's meeting of the Senate Environment and Natural Resources Policy and Legacy Finance Committee, the panel considered a bill that would allow a court review of water quality rulings issued by the Minnesota Pollution Control Agency. Here are some highlights from that meeting.
The purpose of the bill is to provide on judicial review of the Pollution Control Agency final decision making relating to or involving water quality, that the Pollution Control Agency must prove there is a reliable basis for the enforcement of the action. And no longer would the Pollution Control Agency have the benefit of a legal presumption, which the agency has used in prior litigation.
Everyone in this room and across Minnesota is for clean water. We want that policy to be based on sound science coupled with common sense and affordability. This is what I would deem a modest and moderate proposal that we think will help address some of the contention that is going on when it comes to disputes between local governments and state government when it comes to water regulation. No one wants clean water more than the people in our communities. We are the people who are drinking it, bathing in it, using it for recreation. We fish in our rivers and our lakes. When you listen to the intelligent and reasonable professionals that we have on the other end of the table, I think you'll be convinced that there is a problem that the legislature needs to address. And Madam Chair, you and I have talked about that the legislature needs more oversight and more involvement in these types of regulations, and we believe this hearing today will help bring that about. Why is this bill needed? Under current law, we believe the PCA is not conducting external independent peer review. They may be doing peer review internally, but we believe it needs to be external and independent. Cities, we believe, and that we represent, have largely been ignored when we've raised legitimate scientific concerns. And the current legal structure forces the courts to rely on the science of the litigants rather than independent from the parties that are in dispute with each other.
One of the great criticisms that I receive from my constituents over and over and over again is the difficulty that they have in dealing with state agencies in general. So I don't perceive this to be necessarily picking on just the Pollution Control Agency. Each one of us could pick a state agency, revenue, ag, DNR, doesn't make any difference. We've all received complaints from constituents as to the way they are treated by various state agencies in the rulemaking. And this is now a step that we're going to try and address some of those constituent questions, and this is a step in that direction.
These changes, as have been discussed, require the Minnesota Court of Appeals or an administrative law judge to establish a panel of 3 experts. First and foremost, this panel will create delay in decision making. Adding a second layer of experts after the commissioner's decision, after the commissioner consulted its own experts and heard from the experts from groups like ours and CGMC, will add months to every single agency decision under this provision. We hear often about how companies and the private sector are concerned about how slow the permitting process is, yet this process will make it even slower, in addition to being redundant.
We only use peer-reviewed science and data. Most of the time, it is from peer-reviewed journal articles from the national or international scientific community, and most of the time we have had absolutely nothing to do with the instigation, the research, or the publication of those. We do not hire, as a routine basis, people to do peer review. We use the science that the greater scientific community in the country has put out there.
There's a concern raised in some written communication that we've received, it's in our packet, that this proposed judicial review may affect federal funding from the EPA because of delays or noncompliance with the Clean Water Act, particularly should the delay disallow the MPCA to consider and comply with federal mandates and changes, attributable to the delay. So have we examined that question, that the level of delay, the nature of the judicial review might interact with our ability to receive EPA funding?
I don't necessarily agree with those folks who have testified that this is going to greatly increase the time involved and greatly increase the delays. To a certain extent, certainly yes, but I don't see it as being a huge problem.
The bill passed the committee on a 7-5 vote, and the bill will next be heard before the Committee on State Government. You can view our video archives of this and other committee hearings on our website, www.senate.mn/media.